The observations are, now I feel once it becomes a civil court jurisdiction is ousted and generally high court jurisdiction is ousted, why the labor courts or tribunals should not be given the power to grant injunction and stay, either in favor of the environment or in favor of the workman, etc. There are situations where claiming into the section. Therefore, the injunction should be it's no longer a labor court. Now it has become a tribunal. It's a full-fledged judicial forum. So the power of injunction is given. Parties will not be running from one court to another court for injunction relief or interim relief. So this should have been done, which the present code has completely missed. The second one is the division bench of industrial tribunals. They said normally it will be a single judge, but in appropriate cases, there will be division benches. I don't know what for division benches are necessary in industrial tribunals. They said if there is a split, then it will go to the third person who will be a judicial member. It's not at all necessary. On the other hand, the awards of the labor court could be subject matter of an industrial tribunal headed by division bench, which was the provision earlier. I guess the award no doubt single appellate forum could have been created by division bench of tribunal, which will reduce the matters going to the high court to great extent. Yes. 3. This layoff, etc., as I said earlier, what I suggest is, on the other hand, now it has been in statute book, we cannot wish it away. But what we can think about is, why should we go to the government for permission? Why can't we go to the court, industrial tribunals for permission? Same provision, delete the expression government, put the provision industrial tribunal. So we have a judicial decision instead of a one-sided approach by the executive. We all know last many years no permission has been granted, etc. And therefore it could have been given to the industrial tribunal to look into this matter. This would have resolved this issue in a very smooth manner. This is what we should address. Next. 4. This layoff definition is completely outdated. The definition of layoff and the constitutional power in the standing order saying the event of flood, catastrophe, power failure, etc., does not take place. Once in a century epidemic has taken 1820. 1920 was Spanish flu. In 2020, we have a COVID-19. So the situations contemplated under the present code for layoff is simply outdated. The simplest thing is the layoff should be permitted due to business reasons, because that is where we want layoff. If orders are not there or there is stocks are there, for business reasons, we should be able to lay off. So this layoff definition should be really looked into, and relief should be granted on business reasons. Next.